Thank you, everyone who is joining us today on Zoom. Special thank you to our excellent panelists. And thank you to our co-sponsoring chapters in Orange County and Michigan and Philadelphia, DC, and Austin. And I just want to make some brief remarks and get things started because we have a very fascinating discussion and very important discussion we're going to have today. My name is Dan Kaplan. I'm an assistant federal public defender in Phoenix, Arizona, and also a member of the board of the Phoenix chapter of the American Constitution Society. I'm assisted today by my colleagues, Jamie Johnson, another board member, fellow AFPD, and our fearless chapter president, Andrew Jacobs. Our panelists today, in alphabetical order, Katie Fallow is a senior staff attorney at the Knight First Amendment Institute at Columbia University. Katie has focused on this topic of threats to free speech on social media. She worked for some time at a DC firm where she helped convince the Supreme Court that violent video games are protected speech. And in a more recent time, she convinced the Fourth Circuit that a public official's social media account was a public forum, and even more recently, convinced the Second Circuit that Donald Trump's Twitter account was a public forum, which led to an interesting concurrence by Justice Thomas, which I expect we will talk about today. Professor Gautam Hans is an assistant clinical professor of law at Vanderbilt Law School. He runs a legal clinic focused on First Amendment issues and protections. Previously, he was policy counsel at the Center for Democracy and Technology. And if you read the Washington Post a couple of days ago, you might have seen him quoted about the exact topic we have today, the Facebook Operating Board Oversight Board decision and what he expected. Colin Stretch is a lecturer in law at Columbia University, was previously a partner at Kellogg-Huber in Washington, DC, and of course, more importantly, spent many years as a general counsel of Facebook. Right now, Colin is teaching classes at Columbia Law School on such things as internet platforms, law and responsibility, asking questions such as, should Facebook allow politicians to lie in ads? We're very happy to have Colin here today. I don't mind throwing in that I got to know Colin personally when we served together on law review and on the DC Circuit. And he's a very swell, cool guy, by all accounts, quite good at basketball. Professor Laurence H. Tribe is, of course, the Carl M. Loeb University Professor at Harvard. The designation university professor is the highest academic honor you can get from that institution. He's argued 35 cases in the Supreme Court. His American Constitutional Law Treatise is the most cited legal text since 1950. And more importantly, for today's purposes, he is currently a member of something called the Real Facebook Oversight Board, which he, if you visit their website, which you should, on there, he says, it's probably the most important effort in my 50-year career in the law, which is a very significant thing, especially from the mouth of Professor Laurence Tribe. I should add that I had the great pleasure and honor of working as a research assistant to Professor Tribe in my law school days and worked on some incredibly interesting, high-profile stuff, and it was very exciting, still a fond memory. And last, but definitely not least, Professor Eugene Volokh is the Gary T. Schwartz Distinguished Professor of Law at the UCLA School of Law. He's written books such as The First Amendment and Related Statutes. It seems pertinent to point out that he worked for 12 years as a computer programmer. He's written over 90 law review articles, has been cited in 8 Supreme Court cases, and we should probably update that number because, particularly pertinent to today, his very popular Volokh Conspiracy blog, he put a post on that ruminating about some interesting issues of First Amendment and social media, which Justice Thomas cited in that recent case that I mentioned earlier. So the very perfect panel at a very perfect moment, and I'm going to speak as little as possible. I'm going to start things off by asking each of our panelists in that alphabetical order to address the question of what do they think? What is their perspective on that Facebook Oversight Board decision that was just announced? And I'll start with Ms. Fallow.
Thanks, Dan. Since I am at the beginning of the alphabet of this group, I thought I probably should just give a quick high-level summary of the Facebook Oversight Board's decision yesterday. So Facebook had referred 2 questions to the Oversight Board. The first, whether it was justified in indefinitely suspending President Trump's account from Facebook after the events of January 6th. Second, how Facebook should treat the speech of political leaders going forward. And in the decision yesterday, and the Oversight Board received over 9,000 comments from people. So obviously it was of great interest to everybody. And essentially what the board did is as to the question of whether Facebook was justified in suspending or taking steps against the account following January 6th, the Oversight Board concluded that it was because Trump's posts, the Oversight Board agreed that Trump's posts violated Facebook's dangerous individuals and organizations community standard, which essentially is praising or glorifying violent behavior by someone else. So I feel that in the popular press, there was a lot of question about whether or not Trump had, or maybe in the First Amendment press, had engaged in actual incitement under the First Amendment, but the Oversight Board upheld Facebook's determination, which was based on glorifying violence, which of course under the First Amendment will be protected, but this is Facebook, not the government. Then the Oversight Board said, however, the decision to, quote, indefinitely suspend the account was basically made based without any standards governing Facebook's decisions, and that there was no precedent for Facebook doing so on an indefinite basis. And so it essentially said that Facebook should, and the Oversight Board's decisions are binding on Facebook as to the content moderation decisions. And so it directed Facebook to, within 6 months, develop standards for how you treat the account that have violated these various community guidelines, and to have a proportionate response, and to develop standards that would be applicable to everybody, although taking into account the specific issues related to either political leaders or what they deem influential people, influential figures, and then to apply those standards to Trump's account, and to do that within 6 months. And then, the Oversight Board also issued a bunch of policy recommendations, which are not binding on Facebook, but in rendering its decision, it went out of its way, and I thought was somewhat surprising, to criticize Facebook for potentially using the Oversight Board process as a fig leaf, meaning that in referring this question to the Oversight Board, that and accepting the Oversight Board's decision as binding, that Facebook essentially was evading its own responsibility for what its own design decisions or actions play, what role that those played in the events leading up until January 6th. And so it called on Facebook to assess what its design decisions, what impact its design decisions, meaning how its algorithms or other features push news or push posts or contribute to the virality of posts, and to do a self-assessment of how its own actions contributed to the events of January 6th. In terms of at the Knight Institute, we submitted a comment to the Oversight Board, and we actually had urged the board not to answer the question because of this critical missing puzzle piece, which is Facebook's own contributions to the events and the spread of misinformation, et cetera, that led up to January 6th. So, I think that the board's decision that Facebook was justified in taking the action against the account based on its application of its glorifying violence standard, that seems justified. It also seems, I think it's a good idea that they urged Facebook or required Facebook to develop clear standards that can be as much as possible applied, in a generalized way to everybody, and then calling out Facebook on its own publicly to take steps to assess its own contribution.
All right, thank you, Katie. Next up, we have Professor Gautam Hans.
Hi, everyone. Thank you for having me today to discuss timely issues that I think many of us have been thinking about, not just this week, but for many weeks and months and years. So I have maybe 2 points that I'll talk about briefly. First, dealing with the decision itself, which I think I really am grateful to Katie, not only for her wonderful summary, which saves me the trouble from understanding all the procedural components, but also for the excellent comment that the Knight Institute submitted, which I really encourage people. It's very short, relatively speaking, for legal texts, but I think it does a great job of highlighting some of the concerns that I have, not only about the specific instance at issue, but also the broader structural questions about the Oversight Board and its ambit. And so I think the Knight Institute comment did a really great job of, in a short space, talking about those different issues. So this decision itself, I think, demonstrates a fair amount of political savviness from the unknown, because the opinions are unsigned, members of the Oversight Board, although I gather from some reporting that many more than just the 5 members that typically hear of a case were involved in this decision. That was from a op-ed that I think Alan Rusbridger published in The Guardian. So I'm a little unclear on the procedure of it, but I will say that I think that the opinion itself demonstrates a fair amount of political savviness from the members of the Oversight Board, given that they both upheld a controversial decision from Facebook, but also levied a number of critiques, maybe about how the entire process unfolded, as well as some of the structural questions about the abilities of the Oversight Board to intervene in certain kinds of cases. I'm of the group of people who find the discussion of the Oversight Board to be somewhat frustrating, because I think the entire apparatus is bizarre and strange to me. It sometimes reads to me as someone's political science experiment gone awry, which I think technically it kind of was, given that I think Kate Klonick's piece in the New Yorker talks about the origins of it. So I'm very skeptical of this entire enterprise. I think if any other company decided to outsource its major decision-making to some strange quasi-judicial body, we would find that odd. Like ExxonMobil doesn't ask other people where to drill for oil, nor does Blue Cross Blue Shield say, oh, we're going to outsource our health insurance questions to some other group of people. Facebook fundamentally makes content policy decisions every day, some of which are automated and some of which are not. And the idea that there's some reason that we should think that they don't bear the burden of living with those decisions, living with the policies they make and enforcing them neutrally, I think is very, very odd to me. And I don't think I'll ever find it odd. Maybe I'll be persuaded by another panelist or maybe by other thinkers over time, but it's very strange to me. And I think that it's very difficult for me to not read the entire structure of the Oversight Board as political, as messaging, as PR, as part of a coordinated strategy that the company has been developing for many years on many different fronts, sometimes executed successfully and sometimes not, like all companies. Companies are corporations. They have responsibilities to their stakeholders and shareholders. And I don't think it's the fault of the company to try to influence public opinion in this way. I do think it's regrettable that we all seem to be falling for it. And maybe the last thing I'll say is that think about the vast number of judicial decisions, both state and federal in the US, that get decided every day about current issues like labor, reproductive rights, speech, criminal sentencing, and how much airtime one decision from the Facebook Oversight Board about what content moderation decision has played out over the last few days in the media. And this is not necessarily just a media criticism question. I think we all are currently interested in the car crash of Donald Trump and his Facebook account, but I find it kind of depressing that we don't focus so much on other things, which is not to say that we shouldn't focus on this thing. We can walk and chew gum at the same time, but I think it's a hallmark of success that the company has managed to get us to pay attention to something when there are many other things that we could be criticizing or thinking about as well.
Okay, I'm having a little Wi-Fi issue. Hopefully we'll not continue. Our next up is Mr. Stretch. Colin?
Thanks, Dan, and thanks for having me. I'll make 2 notes just on the introduction to begin with. One, Katie Fallow was also our classmate, so at a minimum we have half the panel, the great class of '96, and I'm delighted to know that my law school careers my reputation for basketball exceeded anything else that I might have been known for. You know, this may be a little bit surprising as a jumping off point, but I don't really disagree with much of what Professor Hans had to say. This whole thing is odd. It's a private company that has created this sort of quasi, and it's been emphasis on quasi independent oversight board. Like, who does that and why? And I think it's important to sort of start there, because my own view is that the decision yesterday isn't that big a deal in the grand scheme of things, and is basically the oversight board working as it was intended. If you go back to where this thing came from, you know, the company was faced and continues to be faced with a really difficult challenge, which is it has these content decisions that it has to make. There's just no getting around it. You're going to draw the line somewhere on content. Wherever you draw it, you're going to have to make a lot of decisions. And the people who get stuff taken down that they posted aren't going to like where you drew it. And the people who complain about content and it doesn't get taken down aren't going to like where you drew the line. And so you're going to have a lot of people on both sides of the line and a lot of people unhappy. And that certainly has played out over the years. And it has become, I think, increasingly intense during the Trump presidency. You know, we used to joke that in this hopelessly divided time in this country, there was literally one thing we could all agree on, and that's that Facebook screwed everything up, right? And that does sort of tend to sort of characterize the conversation around Facebook content decisions. Nobody's happy. Nobody's happy. And so the company's, you know, trying to run a business, as Professor Hans notes, and is trying to figure out, okay, we have this very important issue that we have to deal with. Everybody thinks we're screwing it up, and we have literally no way to establish any degree of accountability or legitimacy. And why is that? It's because of out and out regulatory failure. Nobody wants to take this on. Everybody, and I'm talking worldwide, everybody wants to criticize, but there is nobody. If you look at governments around the world, even ones that aren't constrained, I'll use that term, you know, in quotes, by the First Amendment, nobody wants to take on what the standards ought to be in a meaningful way for a social media company. Why? Because it's really, really hard. And so in the absence of any regulatory oversight, in the absence of, say, you know, the rules that govern where Exxon drills, or the rules that govern how a healthcare organization operates, the company is operating essentially in a vacuum. And so they looked to create this quasi-independent board as a way to say, okay, we'll kick some decisions up. We'll try to create as much independence as we reasonably can, given that we're creating this, and they'll make decisions. And maybe that'll create some transparency. Maybe that'll create some legitimacy. Nobody operates under the assumption that this is going to solve the problem, but it may illuminate the problem and generate some degree of understanding and legitimacy. And I think that's what it's done in this case. I think they issued a decision that, I agree, makes a lot of sense. You know, Facebook kind of made up a new sanction for the events of January 6th. And it had significant effect in the sense that it, you know, disabled the then president of the United States from speaking on his platform, not a small matter. And they didn't really explain it very well. And it was sort of a new sanction that didn't have any precedent. So understandably, the oversight board said, that's not good enough. Come on, you can do better. Totally reasonable. And something that I think is, as I said, the oversight board working as intended. I'll just add it's, I'd say incremental in the sense that there's lots of questions, including the important question that the Knight Institute raised about the oversight board's access to information, its remit. Are they going to be dealing with ads? Are they going to be dealing with, you know, people able to complain when content doesn't get taken down, as opposed to just content that does get stricken? Are they going to be able to look into, you know, operation of the product? And that's going to continue to be a tension. The remit was obviously somewhat narrow to begin with. as the board gets its legs under it, you know, I would expect it to expand, not contract, over time.
All right, thank you very much, Colin. We turn next to Professor Laurence Trott.
Thanks very much, Dan. You guys were in the class of '96. Were you in my con law class? Some of you?
Yes, I was.
You were. I sort of remember you, Katie.
Thank you for the apples
Well, I hope you enjoyed it.
and the knowledge, but also.
Well, with the apple comes the knowledge. I think that's what the serpent said. I think Katie did a wonderful job sparing us the obligation to describe the landscape of where we are now. And I very much agree with Gautam Hans that the situation we find ourselves in is odd at best. I mean, the idea of a company with enormous power purporting to outsource whatever moral compass might guide it and whatever sense of social responsibility, apart from maximizing profits, which is its ordinary task, might guide it. The notion that that's odd is putting it mildly. It's extremely odd, but it's not odd that a company with a good sense of PR, as Colin Stretch suggests, would proceed just this way. I mean, when in an interview by Fox a year ago, Mark Zuckerberg said, "Nobody appointed me to be the arbiter of all knowledge and all truth." He was obviously expressing a truth in itself. Nobody expects any private company to worry about the ultimate truth of matters. And because of the power of platforms like Facebook and Twitter, it's understandable that he would say, well, you know, don't look at me, look at them. And the them is some ersatz board that he creates of very impressive poobahs with reputations to preserve. And they then, having been handed the ball, toss it back. Speaking of Colin's basketball image, toss it back into Zuckerberg's court. And it's all a wonderful distraction for us, and it's performative art at its best. But it doesn't address any of the fundamental problems of the algorithms that platforms like Facebook use in order to scrape information from its users and then turn that information around into ways of targeting and amplifying the most violence-inducing and sensational messages. It's a fundamental problem, and it's a problem that the society is grappling with in a way that is very problematic, given our First Amendment and the limits that it imposes on content regulation of private entities. The discourse that ought to take place surrounding Facebook is a discourse that this kind of sensational performance displaces. We ought to be talking about what are the ways in which we can deal with the propagation of demonstrable and dangerous falsehood. We certainly can't, I think, in a system that begins with the premises of the First Amendment, tolerate the idea of some grand commissar of truth that would intervene and say, this is too dangerous a falsehood to propagate. We've got to cut it off at the pass, because once the lie is out there, it can't ever be rectified. We can't have a grand commissar of truth performing that kind of prior restraint role. At the same time, there are certain things we can do in terms of imposing liability on entities with editorial discretion, subject to principles like New York Times v. Sullivan. We have to worry about Section 230 and the degree of immunity that it oddly provides. All of these fundamental issues are essentially put to one side by all of the national focus on whether it was or was not a sufficient remedy to exclude Trump temporarily from this platform. Was it excessive? Did it violate his free speech rights? And we can talk about how much misunderstanding that reflects. You know, you don't have a First Amendment right to access to a private forum. On the other hand, I certainly agreed with Katie Fallow and the Knight Institute, the First Amendment Institute, that when a government official uses a private forum as a public voice, the government activity that that official engages in is subject to First Amendment restraints, which is why I think the Second Circuit was right in saying that Trump's decision to exclude certain people on a content and indeed viewpoint basis from access to his Twitter feed violated the First Amendment. All of these issues are sort of churned up by the situation we confront. And I see it as a wonderful moment, not for distraction, which is what it was intended to be by Mark Zuckerberg, but a wonderful moment for public education. Sort of what is the role of the First Amendment in regulating these enormously powerful private platforms? What are the limits of what government can do? Can it deal with the tools they use, the algorithms they use, even if not the content of their speech? How can that be designed? That kind of dialogue, a dialogue that is salient publicly because of the focus on the immunity of Section 230 of the Communications Decency Act, that kind of dialogue is, I think, potentially encouraged by this moment of confusion about where we are and what the role of government is. And so I welcome the opportunity to play whatever roles each of us respectively can in clarifying what is on the table, what could be done without amending our Constitution, what ought to be done. Certainly the idea of expecting a private owner of a major platform to serve the role of self-regulation and to do it either conspicuously or underhandedly by handing it off to some supposedly independent oversight body, that isn't much of a solution. And when we praise the board for having come down in a reasonable way, I mean, after all, it would have been terrible had they said that a president of the United States who came awfully close to overturning the election by fomenting an insurrection had, you know, every right to continue on this platform. I mean, that would have been terrible. It's great that they didn't do that, but that is only the beginning of the conversation we need to have. Dan, I think you're muted.
Sorry about that. We turn to Professor Volokh.
Thanks very much. I agree with much that people have said, and that Professor Tribe just said. I disagree with some of it as well, but I want to make sure that we are asking what I think is the most interesting and important question, or at least I'd like to ask it. And that question is basically this: whose rules should govern how Americans speak with other Americans? There are many possible answers, but there are at least three that we might focus on. One is, we might say, should be governed by American free speech principles, coupled with a judgment of American speakers and American listeners. And that basically things that are not actionable, incitement or defamation or whatever else, should be something that Americans are practically free to engage in. A second is this immensely rich and powerful corporation. And by the way, people who know where I come from politically know I don't use that as a pejorative. I think they're rich and powerful because they've provided services that people really like. But still an immensely rich and powerful corporation, and it's immensely rich and powerful owners and managers. That's a second possible option, perfectly plausible. Third possible option is basically international law principles, as made and enforced by an international group of decision makers. In some respects, people who were involved in various international human rights decision making, and now this international board that Facebook appointed, who are very self-consciously applying international legal principles. There's a lot to be said for each possible answer. So, for example, many libertarians and other supporters of private property rights might say, hey, option 2 is the right one. Look, this is private property. Facebook, sure, of course it's entitled to control what's said and done on and with their property. And of course, that's historically been so for many other powerful entities, such as newspapers, magazines, book publishers, and such. It's not always, by the way, our rule. For instance, phone companies are common carriers, which can't just cancel someone's phone number or delivery service for like FedEx and UPS, also common carriers, just because they think the person's or group's viewpoints are dangerous or evil. I actually don't think it would be so terrible if Facebook were to say, look, if President Trump wants to engage in even advocacy of violence, or if Maxine Waters wants to praise people who are rioting, or maybe other people, I know there's some dispute about exactly how Maxine Waters' comments should be interpreted, but certainly lots of people have at times praised violent action, praised revolutionary action. It should be left to the legal system to decide whether they are going to be blocked, and not to the phone company to say, oh, no, we don't want that on our phone service. Likewise, not to Facebook to say we don't want that on Facebook. So in any case, this option of letting the corporation make these decisions is possible. Again, also you might like international law principles. You might think that, look, international free speech norms are better than American free speech norms. Or maybe American free speech norms are better when it comes to throwing people in jail or letting people be sued, but international free speech norms are better when it comes to Facebook deciding who to eject from social media platforms. And then, of course, one factor that comes in here is, do you view Facebook as just like another newspaper? Obviously, newspapers have editorial discretion what to publish. Or do you view it as something much more central to modern discourse? And by the way, the Facebook Oversight Board seems to view Facebook as something more than just a normal newspaper. The line from there is, Facebook has become a virtually indispensable medium for political discourse, and especially so in election periods. So especially when it's a closed debate and a closed election, I think access to Facebook does become a very important free speech question, even if it's not, I agree, a First Amendment question. So I'm inclined to tentatively lean towards option 1, that I do think it makes sense that when it comes at least to Facebook's hosting decisions, Facebook's decisions about who can use Facebook to communicate to willing listeners, to eager listeners, I think there's a good deal to be said for treating Facebook like we treat the phone companies, like we treat FedEx, like we treat UPS. Phone company can't say, oh, you know, I think so this phone line you're using as a recruiting phone line for the KKK or for Antifa or for the socialists, and we just don't approve of that. We think it's bad for the country, so we're going to cancel your phone line. We don't let phone companies do that, and I'm not sure we should let Facebook do that either. And I'm particularly moved, by the way, by the dissenting opinion, the minority opinion from the Facebook Oversight Board, which is mentioned by the majority opinion. We don't know how many people were in the dissent. Was it close? Was it not? When the Facebook board grows from 20 to 40, will the dissent become the majority? They don't tell us. They don't even tell us. Is it like at least Supreme Court, you know, is it 8-1 or is it 5-4? But my view is a minority opinion, especially one that the majority seems to be interested in specifically mentioning, is it may become the majority at some point. So one of the things that I noticed, for example, is the minority opinion said, you know, Trump should have been banned in part because he was saying these racist things, like talking about the China virus. You know, we can debate whether he should be faulted for that or not, but I don't think that international law principles or Facebook's personal views ought to influence what a president or what a candidate for office can say through this very important medium to the voters. Or another line from the minority. The minority says that our assessment of a proportional penalty on Facebook's part should be calculated to, quote, serve as both a deterrent to other political leaders and, where appropriate, an opportunity of rehabilitation. Now, I'm a huge fan of deterrence for political leaders. I just think that those deterrents should be the threat of voters throwing the bums out, and not the viewpoint-based judgments of a massive corporation applying international law norms. So I think there's a lot to be said for American law treating Facebook as to American speech, that is, and we can figure out how to define that, as something like phone company, which is a common carrier which can discriminate based on viewpoint. I'm not at all sure this is right. I want to float this as a possibility. I'm inclined towards it at this point, but I can easily be persuaded to the contrary. And there are, of course, all sorts of complicated questions about Facebook's own speech. Like, I'm not sure that Facebook should need to promote this speech at the same level it promotes other speech that it does like. And likewise, by the way, I don't think it's just American. I think Canadians should insist that Canadian speech to Canadians, and especially Canadian politicians' speech to Canadian voters, should be governed by Canadian rules rather than by American rules or by Facebook rules or by international law rules. I think that's more consistent with our traditions of democracy. And that's why, even though I'm usually quite skeptical of government regulations of private property, for a company that's this big and powerful, this much of an important monopoly in its own particular niche, I'm thinking that some degree of treatment, again, like the way we treat phone companies and UPS and FedEx, may make a lot more sense.
Did it again. Thank you, Professor Volokh. Professor Volokh's comments did touch on something else that I mentioned earlier, the question of regulation of social media under the doctrines of common carrier and similar doctrines. Justice Thomas discussed some of these things and actually cited Professor Volokh's blog in his opinion in the Knight case, Katie Fallow's case. And that does open up another topic. I wonder if people have thoughts and views on the appropriateness and the usefulness of applying those doctrines to social media companies.
Let me ask a question of Eugene. At what point does a company merge into the model of a public utility? I mean, is it the fact that it's the internet that does it? Is it the reach, the number of people who use it? If a newspaper were suddenly to discover the magic formula for having sort of enormous reach, and then were to add an interactive component so that it became sort of more like Facebook or Twitter than like the New York Times, would it then move into the zone in which you think it's a better thing to treat it like the phone company? Remember, it begins by exercising editorial discretion. It selects what it permits on the medium, and then gradually it becomes more and more influential. What is it that makes it cross that line? And mustn't it be a line if we're to have some kind of legal principles govern it?
I think those are great questions, and often the devil is in the details. Maybe there's no satisfactory answer to those questions, which is a good reason not to regulate. Always many good reasons not to regulate. Here's my very tentative thinking about this. First, if we look at the way common carriers are usually defined, they're actually not defined based on size. You could be a modest-sized trucking company, or at least it doesn't have to be a monopoly or near to it, and be a common carrier. You could be a relatively modest-sized telephone company, including a cellular company, so you're not even a monopoly in a geographical area, and be a common carrier. So as I understand it, it's usually sectoral, that it depends on what line of business you're in. But one thing that might animate our judgment about whether to institute common carrier status is whether we think that otherwise we would have these private entities having too much power over important facets of life, and especially over public debate. Incidentally, not that I'm at all fond of the fairness doctrine and the old rules, some of which still exist, with regard to regulation of broadcast media, but we do have, for example, for broadcast media, certain rules about, for example, requiring them to allow time to put candidates for federal office, which are attempts to try to impose some common carriage type obligations in situations where we think that that there's a really serious problem or potential problem with control over public debate. Again, I'm not sure that's the right model, but those are the kinds of things we might look to. I will say that for newspapers, to me, one of the most important functions of a newspaper is precisely that it deals with the problems of information overload for us, right? We can't possibly read everything that's written out there. New York Times can't print everything that's written out there. It provides a tremendously useful service to its audience by selecting what to include and what not to. Partly based on viewpoint, at least even if it tries to be even-handed, there are certain viewpoints it won't cover because they're just extreme and ridiculous. Partly based on whether they think it's timely, partly based on whether they think it's factually accurate and the like. So that's why I think for newspapers it would be a disaster to treat them as common carriers. Likewise for Google search, you don't want Google search to be content neutral. A content neutral search, even a viewpoint neutral search, would be a useless search. But I think when Facebook essentially says, we will allow you access to 99.9% of what's out there, or maybe 95, depending on what denominator you use. We're not really, at least as to our hosting feature function, we're not really solving the problem of information overload. We want to present as much speech by private entities as possible. Then in that case, it seems to me that looks a lot less like a newspaper, a lot more like a phone company. Remember, a phone company could, in principle, say we want to exercise editorial control. We want to ban the Klan and the socialists and the communists and people who just don't approve of the phone company, but we don't let them. One way of thinking about it, and this is an analogy that may not be terribly helpful, but I just want to float out there, especially, by the way, can we use first names if we can? Let me say Katie, and please call me Eugene, but especially since Katie is here and because of the Knight Institute's litigation, remember, this is one of these issues that comes up in this question of when the government property is being used for speech. Do we treat it as government speech where the government has editorial control, or do we treat it as a limited public forum, which is a place where there's lots of speech by third parties? So if the government wants to put together a website, it can decide based on viewpoint what goes there. If the government wants to publish a newspaper, it can do that and engage in viewpoint-based decision-making. If the government wants to set up like a university, set up a panel like this one, it can invite people based on viewpoint, right? But once it gets to the point of being sufficiently unselective that it looks like it's opening it up to a wide range of people, at that point we say it's a limited public forum and we don't allow it to discriminate based on viewpoint.
I was going to jump in here. Yeah, what I find Eugene's discussion and idea about this common carriage, treatment of the social media companies extremely interesting. Although I'm not sure I'm as convinced by it. Although you've expressed that you're not sure either. I certainly was surprised to see it in a concurrence in our case against Trump. It's because it wasn't actually really related to any of the issues in that case, which was whether, as Larry said earlier, whether Trump had violated the First Amendment by blocking people. And he is undoubtedly a government official and thus subject to the First Amendment. And, Justice Thomas's concurrence, as much as, I have my own personal, attachment to that case, it was certainly it felt like out of left field but also very interesting and provocative. I mean, it was sort of saying, you think it's bad that President Trump blocked a few people. Well, look, Facebook has so much control that it can actually block the President of the United States, who has 85 million followers, or sorry, not Facebook, Twitter. And so, again, I don't think it really actually related to the issues in our case, but it does relate to this fundamental question that we're all sort of talking about. And I think everybody agrees, including a lot of people from, maybe it brings together even at the same level as people dissing Facebook, as Colin talked about, but, that people are really concerned about the concentration of so much power in these, huge companies run by a couple people over the speech environment. And although some people might say, I'm so glad that Trump is off of Twitter or Facebook, you always have to think, well, what if they, deplatform someone I do like? And, am I okay with living with that? On the common carriage idea, one question I had is for you, Eugene, is under that, if there were common carriage obligations imposed on the social media companies, could they engage in any content moderation? And the reason why I said it is because certain things, for instance, they have banned misinformation about vaccines or about election. But there are obviously, and we all bemoan this, but in our increasingly partisan and media bubbles, where what you consider a fact or not fact often just is actually a viewpoint or a world viewpoint. And I'm trying to think about how that would actually apply. Let's say you had a FCC and someone says, Facebook,
Right.
I posted vaccine misinformation or whatever, vaccine information that I believe is true. And they kicked me off, but that violates this
Right.
non-discriminatory.
So I view that as a feature, not a bug of the common carrier model. So imagine that a phone company sends you a message saying, we feel you are distributing misinformation on your texts. Or you are an advocacy group and you're using the phones to call and solicit funds, and or not even solicit funds, call get out the vote, call spread a message. And we feel that you're advocating ideas that are false. For example, we heard that you really like socialism and you claim that socialism will make people better off. That's obvious nonsense. All economists, or at least all credible economists, recognize that it's nonsense. And we have a track record for socialism. It is pretty appalling. It's just fake news. We don't want you to use our phone lines for that. I think the answer is, well, that's you're a common carrier. That's not a decision for you to make. And I think that's a pretty sensible position. I should add, by the way, one thing that bothers me, and I should say, I am all for vaccination. I wore masks. I'm all for those things because, I think the smart money bets on the credible experts, even if they're sometimes wrong. But one thing that really bothers me is people are saying, well, this is obvious falsehood. Well, it's one thing to say, yeah, the Holocaust denial is obvious falsehood. Why? We've had decades of scholars studying very closely a vast range of evidence to the point where some years into it, we figured out, this is pretty clearly the truth and that it comes out from the fog of war. I'm still not in favor of banning Holocaust denial, but I think that that's something where you could say we could take that to the bank. To say in the middle of a pandemic which is involving a new disease where the CDC and the World Health Organization every couple of months changed their views for perfectly understandable reasons. They changed their views because the evidence was unclear then, it's now differently unclear now. To say that, oh, well, no, there's an orthodoxy, and it's true, it's only been an orthodoxy for 2 months, let's say, because it displaced the previous orthodoxy 2 months ago. And now everybody has to adhere to that. That, I think, is a pretty poor way for the search for truth and the marketplace of ideas to operate. And not that they operate perfectly on their own, they don't, but I'm not sure that Facebook sort of saying you must follow the orthodoxy is the right approach. Now, I do think it's a very important question. What segments of what Facebook does should be subject to common carrier status? So, for example, I think Facebook's decision about what to pitch stories you might like, let's say, I think that's very much their speech. I think they ought to have First Amendment rights to decide what to promote this way. As opposed to what I call its hosting function, which is just my speaking to my friends that have chosen to subscribe to me. And then there's the intermediate question. What do you do about comments on other people's tweets, for example? There, you probably do need to keep things usable. You do need some degree of moderation, if only to block spam. Imagine if they couldn't block spam on comments, but maybe even to block sort of super rude or borderline threatening or other such stuff. So, by the way, that's similar to common carriers, right? Sprint, Verizon, UPS have lots of free speech rights to say what they want to say. They could probably even kind of, when they deliver stuff to you, they can also deliver their messages. But that doesn't mean that they have the right to control what other people say on their platforms.
I think a fundamental question really is, from whose perspective are we asking these questions? Are we imagining a court applying hopefully manageable legal doctrines to characterize various deliverers of information as either common carriers or not? Or are we imagining that we are designing an optimal society from the ground up and figuring out where we would like to put things, or are we describing what we think is a more accurate picture of the reality? I mean, it's hard for me to know from what perspective to view any of this. I mean, there are a lot of sub-questions about how do we deal with the various algorithms that communicative entities employ to target their audience and so on. But I'm having a hard time knowing, you know, from what perspective to judge whether I agree or don't agree with Eugene.
I'm imagining a federal statute. I think that would be the clearest thing. Not to say that Congress is A, likely to institute such a statute, maybe not, or B, likely to write a good one. That's a whole separate question. But I'm imagining Congress creating a statute saying, basically, Facebook and other such things defined in a reasonable way are common carriers as to their hosting function, which we could either say requires content neutrality or viewpoint neutrality or something else along those lines. That's what I'm imagining. I'm not saying this is the right way of interpreting the First Amendment, by the way, as mandating common carriers to private entities. I'm a big believer in the state action doctrine.
I understand, but I do think the devil is very much in the details. I remember arguing a whole bunch of cases involving the breakup of the Bell telephone system into various subunits, and Congress passed the Telecommunications Act at a point where the question was whether attempts to treat the baby Bells as merely telephone companies or whether they could be permissible content providers was a question both under the First Amendment and as a matter of policy. And I remember thinking at that point that it all depends really on sort of what your frame of reference is. You say, Gene, that it's a question of designing a statute, but once you have an act of Congress, which is bound to have ambiguities, and you have the background principles of the First Amendment, which are themselves not self-defining, where do we sit and where do we stand as we try to answer these questions? I mean, I find your approach interesting, not necessarily convincing, but I ask myself sort of from what perspective am I evaluating it? And that's my big puzzle. Is it a utilitarian question of, you know, what would work best for the society as a whole? Are there certain sort of fundamental ground norms about the structure of free speech internationally or domestically that we need to preserve? I'm finding myself more intrigued than illuminated.
Great questions, all. Great questions.
So one perspective that I bring is, well, you know, as a former employee of one of these companies, but also as a user, you know, one, I think, unfortunate truth of the internet is that in the absence of moderation, and I think it's fair to say that common carrier treatment means less content moderation, maybe not none, but a lot less. In the absence of fairly aggressive content moderation, the services get overrun with nudity and pornography. It's lawful speech under the First Amendment, but a sad truth of this country is that if given the opportunity, people will share lots and lots and lots of objectionable content, which makes it just difficult to use, right? People aren't going to want to show up at Facebook if every time they load their feed, all they see is you know, offensive content. The same is true of violent and extreme content that is within the bounds of the First Amendment. If you roll the clock back about, call it 8 years, all anybody wanted to talk about was terrorist content on Facebook and how Facebook wasn't doing enough to moderate it. And the company, you know, put a lot of resources against that. And in my mind, for good reason. So I tend to think that that a world in which content moderation is severely drawn down is going to be a world in which users don't like the services very much, including me. So that's one point. The second point I'll make is that I think if you create a world in which companies invest less in content moderation, which I think common carrier regulation would accomplish, you end up diminishing the opportunities for innovation in this space. I think I'm with you, Eugene, on this question of kind of ought we be censoring misinformation, COVID misinformation, and the like. I tend to have a pretty broad conception of what I'm allowed to see online. But I am generally, I think, like most people, worried about the spread of misinformation online. And I think there will be, in time, better tools to understand the source of information, the sort of quality and integrity of information. I'm using obviously fairly elusive terms, but I think the companies have a major incentive to make these problems more manageable from the user's perspective, to make the services better. And if they're not doing that as a business necessity, if they're not investing in it as a business necessity, as I think they would not be in a common carrier world, I just think as users, our tools are going to be less than they could be, and that I think is a consideration at least. That does sort of leave me in the place of, okay, well, what are you for from a regulatory standpoint? Larry said earlier, he talked about algorithmic transparency. I do think there is space there, and I know the EU is doing some good work in this space to at least understand better how companies sift and order information. If we can understand better, we may have a shot at more effective regulation. So I'm in favor of algorithmic transparency. I also would like to bring back the conversation around net neutrality, but I'd like to have that conversation with respect to other aspects of the technology stack. When Parler went offline, right, there was a fairly fundamental tenet of net neutrality, which was access to lawful content, that was not honored, right? There was plenty of lawful content on Parler, even if people didn't like it, that suddenly disappeared from the internet. And it disappeared from the internet, not because of anything that AT&T and Verizon did, but because of what cloud service providers did and what app store providers did. And that's just a question, I think. If you believe in net neutrality, I think we ought to be having that conversation. So how far down the stack, or up the stack, depending on your perspective, should we be looking at when deciding whether access to lawful content is something we really, really believe in?
I completely agree with much of what Colin said. First, that I think that any kind of regime that disincentivizes a platform from creating a comprehensive content moderation scheme, which is consistently applied, which is, I think, where many of my concerns arise. Any regulatory scheme that disincentivizes platforms from doing that is basically going to lead to a proliferation of HAMs, and you're not going to get usage, right? People are going to be deeply unhappy with that kind of world, which is something that I, have argued in other settings. I also think that a world in which edge providers, social media companies, for example, are governed under some form of common carrier regime and infrastructure providers are not, is completely upside down, for the same reasons. And that, if we're going to start with thinking about common carriers regulation, AWS is a much better venue for that than Facebook, in my mind, given the real concerns about technical, infrastructure and serviceability and talk about accountability. I mean, the Cloudflare CEO basically said, I don't like having this power, but I'm going to use it, and we shouldn't be happy about it. I'm like, I don't understand. You need to talk to your communications people because this doesn't make any sense. The other thing I would say is that, if we're talking about algorithmic regulation or any kind of analysis, I think it's very clear that if any kind of algorithmic regulation were to pass at a state or federal level, you would see a First Amendment challenge pretty fast, because the companies are, I think, pretty, and I think that they would probably have a fair amount of success given the vast array of deregulatory First Amendment challenges that have been successful in the intermediate and Supreme Court in recent years. So I think there's a multiple front question here. Like there is, the antitrust questions, there are the privacy and data questions, and there are the speech questions. But I think, oftentimes when I talk to students or I talk to reporters about this, I emphasize that it's very difficult to disentangle this from the puzzle or Gordian knot, or choose your metaphor, of what's happening.
I should say this all makes a lot of sense, and Gautam, I think the answer may be and. Maybe we should. You're quite right that if we regulate Facebook, you need to or treat it as a common carrier. There's a great argument to do the same as to Amazon Web Services. Maybe both are right. But Colin, as to what you were saying, the funny thing is you can't access Donald Trump or anything posted apparently by people who are kind of including his videos on Twitter. But there's lots of porn on Twitter. Twitter does not prohibit porn. Twitter does have a sensitive content warning and such, but the fact that there is a Twitter feed called All Porn All the Time, I don't know that there is one, but let's say it is, doesn't affect me so long as I don't follow that Twitter feed or don't go to twitter.com/allpornallthetime. Likewise, you'll only see Donald Trump's posts on Twitter if you've either subscribe to them, or let's say follow them, or follow somebody who passes them along, or if Twitter recommends it, as you might be interested in this and that. And there, Gautam, I agree, actually, there would be a very strong First Amendment argument as to Twitter saying we don't want to recommend it. So that's why I think it's important to be focused on the different roles of platforms. If platforms have to recommend just the top 10 sites, well, then a lot of those are going to be porn. If platforms have to allow unlimited comments, let's say on Twitter, on everybody's Twitter feed, then yes, there's going to be a lot of spam and a lot of porn spam and such. But if platforms simply can't kick somebody off of Twitter, of having a Twitter feed or a Facebook page where they can communicate to their willing viewers, then I'm not sure how that's going to make that unusable for other people. If they don't want to see it, they don't have to go there. Now, there is the separate factor of bad for society if they don't do that. And that returns us to this question of, is it better for society to have these very powerful platforms engage in content moderation of bad content because it's bad for society? Or is it better to leave it to a marketplace of ideas type?
It's a good observation, and I think to me it goes to so much of why the discussion in the content moderation space is off base, and it takes us back to actually the original point of the Knight Institute brief in this Oversight Board case, which is if I post, I don't know, probably half a dozen followers on Twitter. I don't know. If I post something on Twitter, very few people see it. Doesn't really matter. However offensive it is, right? If Eugene, you post something on Twitter, it's more meaningful. So should a company that's engaged in content moderation be focused on the fact that I had this one quite offensive or objectionable comment? No, they should ignore it, and they should pay much more attention to what you've posted. Unfortunately, to the extent we've seen any regulatory appetite to deal with content moderation, it takes no account of this incidence of viewing content, right? And that's the measurement that matters. I had been assuming that under a common carrier regime, the regulation would impede ranking of content, surfacing it in my feed, not just whether something can be posted or not. So if that's a long way of saying I'd be much more comfortable with a regime in which anybody can post whatever they want as long as it's within the bounds of the law, provided that the companies are allowed to engage in content moderation. So they essentially, black hole the offensive stuff, except for people who go seek it out. That's fine. I see. I think I'm not sure I'm reading your expression right, but I feel like maybe I haven't made the point clear, but happy to elaborate further.
All right. Thank you very much. Anyone else want to weigh in on that subject? I wonder if I could draw the focus a little wider and a little more into the future. There's a fascinating interview article with Professor Tribe that came out fairly recently. He talks about writing a memo for his justice on the Supreme Court, which became the Katz opinion. I've always kind of seen that as an opinion which made kind of a leap instead of an incremental kind of development that we usually see. It made a leap forward to deal with new circumstances, new technologies. Justice Thomas made a comment about there being a problem here of applying old doctrines to new platforms. I wonder if people believe or feel that First Amendment doctrine, state action doctrine, other pertinent doctrines, that this is a moment for one of those kind of leaps to address these developing technologies.
Maybe, Dan, I should say just a word or two about that Katz issue. The question long ago that confronted the Supreme Court was how to redefine, or whether to redefine, the idea of search and seizure in a world in which physical boundaries and territorial definitions no longer held, in a world of electronic surveillance, and in a world in which information was not territorially bounded. And in the Katz opinion itself, the question was whether, given the Supreme Court's old doctrines in Olmsted and Goldman, saying that you don't have a search or seizure unless you have a physical penetration into a protected space defined by the laws of property, you don't have a search and seizure, you don't therefore implicate Fourth Amendment concerns. And the issue before the court was whether electronic surveillance, wiretapping, and the like should continue to be utterly immune from Fourth Amendment scrutiny simply because the way in which search and seizure were conceptualized at the time the Constitution was written and the Bill of Rights was written really involved entering a physical space, somebody's private property, to search and seizure. I was clerking for Justice Stewart at the time. It was clear already that electronic surveillance was the order of the day. The question was whether we could replace the notion of trespass into a physically protected area with something else. And the something else was reasonable expectations of privacy, justifiable expectations of privacy. But the problem with that was its circularity. That is, if the government makes it clear enough to people that when they use the electronic telephone system, or today, the analog would be when they engage in cell phone conversations or send texts or engage in searches on the internet, they are basically inviting surveillance by a big brother. If the government made that clear enough to people, would that not defeat the claim that there was any justifiable or reasonable expectation of privacy? So the notion that I persuaded the court to adopt, though it hasn't played much of a role in the jurisprudence since, was that you needed to take into account not just the Fourth Amendment and the values it preserves, but the First Amendment and the values of open and free communication in order to break the circle. So that the question was, if everyone had to expect that their every conversation, their every internet search was subject to governmental intrusion and governmental discovery, would that not unduly inhibit the freedom of communication in ways that undermined the values of the First Amendment? And so the language that the court adopted was, we have to assume that people expect their conversations on the telephone system to be private in the absence of a valid warrant, if we want to preserve the values of the First Amendment and not just the Fourth. And that pointed to a way of understanding the Constitution that did not contain each provision, each clause, each right in its own little cocoon, its own silo, but looked instead at the interconnection among them, the way that the constitutional space was curved around the various amendments. That's what I think Dan was referring to. I'm not sure how it relates to our conversation today, but I continue to believe that a helpful look at constitutional values requires connecting the dots and not simply looking at silos. That perhaps is related to my question about from what perspective to assess Eugene Volokh's interesting proposal about treating social media platforms as though they were common carriers. I don't think we can assess the virtues or vices of that simply from a utilitarian perspective, but have to look at them from the perspective of the various sort of polar values that the various constitutional points in the constellation represent, and then the way those values connect to one another and create an overall space that we're comfortable living in. I know I've thrown quite a curveball into the conversation, but and I will not insist on pitching any further ones, but hopefully that will generate some response.
Well, sorry.
I was going to say I hear a lot of silence.
Well, let me. Sorry.
Well, I was just going to say, in response to your question, I think the point Professor Tribe makes is, I think made a lot of important points there, but one of them is you need to look at the value of expression. Like, one of the things about the First Amendment is it's not just something where you look at whatever government restriction is that we're talking about, but you're trying to understand, okay, you want people to be able to use the phone and not think the government's listening, right? Otherwise people aren't going to use the phone. I tend to think that sort of interest in expression very much ought to color the debate we're having about the appropriate regulation of social media. Usage has exploded. In my mind, that's good. There are obviously some challenges that we need to work through as a society, but we do spend a lot of time and attention focusing on the content we see online that we don't like. I tend to think the larger picture includes, some pretty good developments in terms of the ability of people to express themselves, the ability to find information online. There's a lot to be said for that. That's a long way of saying I don't see the need for a great leap forward in the mode of cats in terms of First Amendment jurisprudence. I'm sure others will disagree. I don't see that much of a problem with the general sort of arc of where we are on this journey. And I think the First Amendment, including its values around expression, will help us sort of stay on that path of encouraging expression with limited government intervention as we work through these challenges and land ultimately in a better place.
I would just say that I disagree slightly insofar as I think that, well, let me back up and say, I think that there are a lot of really foundational First Amendment doctrines that lately some interesting alignments of people have become more interested in revisiting. And I think the concurrence that we've been referring to, Justice Thomas's concurrence in from the denial of cert in the Knight Institute versus Trump case is a good example of this, where I think you see his writing there, preference and views that I think are different than what I would have expected in the past, and maybe different from what he might have expected in the past, although I can't psychologize someone I don't know, or even someone I do know, since I'm not a psychologist. So I think that, questions about state action, questions about the role of, thinking about this common carriage issue and how we define anti-discrimination mandates, the role of the First Amendment when it comes to the company's own First Amendment interests and goals, which I think goes to a lot of why content moderation is justifiable, given that, the company can run itself the way that it wants to, different platforms have different policies and what they allow and what they don't. I welcome that, frankly, because I find there's a reason that I don't teach a First Amendment lecture, because I find First Amendment doctrine to be hopelessly confusing and incoherent at times, or maybe all the time, and lacking any kind of, to my mind, foundational theory that makes a lot of sense for me and for students. So whether or not we would see something along the lines of cats, I don't know. But I've been using this, the bankruptcy line of gradually and then all at once when it comes to doctrinal changes in this area, because I do think that there, Genevieve Lacker, who teaches at U Chicago Law and is a First Amendment expert, has written really persuasively, to my mind, about some of the ways in which these foundational concerns are worthy of being revisited. And while I'm less sanguine about the possibility of that, I probably should say that I think that there is more appetite for it. And, there are only a very few people who have the power to make these kinds of changes. And when they decide to change their mind, they can change their mind. And then that has happened before in many other areas.
So I think the thing that is most likely to be worthy of re-examination over the next 20 years or so is the state action concept. We say that we don't want Big Brother, the government, to be listening to our telephone conversations because that would make us less free to speak. But we don't mind, apparently, when Facebook is scraping our identity information in a way that we only nominally accede to as a result of its ways of its business model, the model that Shoshana Zuboff, I think, rather powerfully describes in her book on surveillance capitalism. I think the question of whether huge platforms like Facebook ought to be distinguished as sharply as I tend to when I'm being very doctrinal, separated from the government, is a good question. I mean, clearly, Zuckerberg regards himself as more powerful than most governments. He talks about the Oversight Board as a Supreme Court. That's not just a metaphor. Should we perhaps think of it as closer to a government, not so much in terms of American law? I really don't believe we should reconfigure American constitutional law to obliterate the state action doctrine. But we should remember that most constitutions don't have a similar doctrine. Most constitutions do not draw as sharp a distinction between what the fundamental rules are with respect to private behavior and governmental behavior. In our system, it would be almost unthinkable because, after all, the Constitution is a law about government, not a law about private behavior. But if we take, again, a focal point that isn't quite as parochial and ask globally and internationally how constitutions work, they don't always embody that kind of sharp distinction between the public and the private. And I think that's a distinction that is not likely to last in another century or two in our constitutional order.
So, Larry, I agree that there is a state action doctrine under the U.S. Constitution. I think it's a very important doctrine, but it leaves questions about how to regulate private entities to Congress. So I think if you're right that Facebook is kind of like a government in its magnitude and its influence in certain respects, then that seems to me to cut in favor of regulating it and imposing kind of restrictions that we impose on our government under the First Amendment. Just to give you an example, which is not at all, pardon?
I was going to say, and on common carriers under your dispensation.
Right, exactly. And now let me give you an example which is not at all completely on point, but maybe somewhat analogous. About half the states have statutes that limit private employers' ability to fire employees based on political activity.
Right.
A few of them are focused on just electoral activity. Some, like my own California, says political activity, but says that's covering the advocacy of any candidate or cause. And one reason, the theory behind these laws, which, by the way, some of them are very old, some of them date back to the late 1860s, and the earlier laws banning discrimination based on voting are actually among the first anti-discrimination and employment laws in American legal history, long before race and religion and union membership. And I think the theory was, private employers can often have such power through the influence they have on their employees over political debate, then we need to constrain that in some measure.
Right.
So maybe the same thing is there. And if that's so, then Colin, this may relate to your point that if we don't approve of the government restricting terrorist advocacy, unless it really is in the category of conspiracy or solicitation or incitement, if we don't approve of the government banning fake news, then maybe we might say we should have a similar rule to these very large and powerful entities, for these large and powerful entities, precisely because the state versus private entity line, which is very clear between you and the state or me and the state, becomes a lot hazier in terms of their influence and possibly damaging influence in public debate when it comes to Facebook as compared to the government.
Right, and it's not only giant corporations. I mean, I think about Marshville, Alabama, a little town in which the town had total control over all of its residents and employees because it was a company town. And I think of a small newspaper in a tiny village, which might have as much control, at least in the day when relatively few people had internet access, as much control over the information sort of menu available to the people in that town as Facebook does globally now. So it's not simply a matter of scale and size, it's a matter of sort of the relative degree of exclusionary power.
Yeah, although I'm not sure the global lens is the right lens. I mean, now we're sort of veering a little bit into, questions in the antitrust space, but this will not surprise you to hear that I view that analogy as a relevant one, but not apposite, because I look at my phone, I've got half a dozen social media apps on it. My kids, I've got 3 kids who are all, teenagers. They've never been on Facebook. And instead they're on TikTok and Snap. And so, and if you don't like, Facebook's moderation policies, you can use Twitter. If you don't like Twitter's, you can use YouTube. If you don't like YouTube's, you can use Clubhouse. There are options. Now, a lot of people use Facebook, obviously. But is that because it has some sort of, again, this is not something we're going to solve on this call, but is that because they've locked you in, or that's because the experience is, they do a decent job at connecting people, and their moderation policies, much as we like to criticize them, are, kind of leave you with a news feed that's more or less what you want to see. So that's a question. It's not just a rhetorical one. I will say, if you, I think and again, this is the point I made earlier, if you decide that people operating in that space have a certain set of requirements, I do think you limit the choice you will get online with respect to the type of moderation you'll see. And that would be, I think, to the user's detriment.
Meaning there would just be much less, everyone would be sort of uniformly very little content moderation.
Everybody would be uniform wherever you set the bar, everybody's trying to meet it. And rather than having, some degree of variety, which I think is, a lot of what technology tends to offer.
I mean, I think that's one of the questions about the sort of analogy to the phone company. I agree with the idea that the phone company should not be telling people, you can't use Verizon because I don't like your political views. On the other hand, I wondered how much the analogy of how much you're exposed to speech of others, which of course, in generally, sorry, my cat's trying to pushing him away, but how much usually, you don't want to have the heckler's veto, et cetera. But on the other hand, how do you weigh the environment? Because something like Facebook is going to say, we don't want to have porn on our site, right? And so Twitter is going to allow, we are going to have porn. And so that gives you a choice. And this would make it so that you don't have a choice. So
the problem with the choice model, which I think I'm all in favor of choice in most respects, but the problem is when you've got close elections, to say, well, okay, we're going to ban this candidate from this particular platform that has hundreds of millions of users, and perhaps, let's say, 80% of the users who are in the jurisdiction for this election. But you know, you can go to Clubhouse and you can talk to whoever happens to be on Clubhouse. That will very powerfully affect the debate. And that will have what the minority on the Facebook Oversight Board said, well, it will have a deterrent effect on candidates. The candidates will be deterred from saying bad things as measured by the Facebook Oversight Board applying international law principles. It's just not clear to me that that's something you want for American elections. And again,
but isn't that counter speech and action? Isn't that what we have always said as one of the foundational points of the First Amendment? That counter speech, you know, is what we want. And if someone is sort of out there and the platform doesn't want it, I mean, I don't know if I necessarily agree with this, but I think this is partially what we've endorsed in First Amendment law, and certainly what the courts have been into.
I'm all for counter speech. So that is to say, Facebook, for example, actually, I blogged about this. People are complaining Twitter is censoring someone by putting up little responses, for a response, go see here, or for a fact check, go see here. I said, you know, that's Facebook speech. Excuse me, Twitter speech. That's Twitter's counter speech. That's exactly what we should be seeking. But I don't think that kicking someone off a platform is exactly speech. You know, it's an interesting question whether it's an exercise of First Amendment rights to not be compelled to host things. Turns out there's a lot of complicated case law. I'm inclined to say that Facebook wouldn't have a First Amendment right to kick someone out, just like a private shopping mall doesn't have a First Amendment right to exclude leafleters. But in any event, it seems to me that Facebook and Twitter counter-speaking is one thing. Facebook or Twitter just saying, leave our platform, go to some other platform where you won't really be able to reach the voters the same way. I don't think that's counter-speaking. I think that's just kicking someone off your property. And, you know, maybe that's a matter of property rights, but it's not really a matter of counter speech.
But if you're talking about Pruneyard, like
I think we ran into our time limit. I wish we could go another 2 or 3 hours. This is an excellent, fascinating discussion. Thank you very much.